Hi there, this is Jonathan Ginsberg, and I'd like to go over with you the four main reasons that I've come up with why cases are denied, so that you can hopefully avoid this type of situation in your own case. The first reason that many cases are denied is that the claimant, you, don't have sufficient medical treatment. Judges expect you to have ongoing medical treatment with a doctor, that you're trying everything the doctor suggests. It's just not good enough to say, well, the doctor wasn't helping, so I figured why bother going. You really need to have an ongoing long-term treatment record. The second thing is that if the doctor prescribes you medicines, you need to take those medicines, but if you don't have any pain medications and you're claiming pain, that's a problem. If you're claiming that you've got significant pain, that's why you can't function, you can't think, you can't get up and go to work, but you're taking BC powders or aspirin, that's not going to be very compelling. So if you're claiming pain, there really needs to be pain management involved, or pain medications at the very least, to show that your pain is at such a level where you need prescription pain medications. Third thing I think that really hurts cases is people who try to work part-time while their application is pending. Social Security sees things in black and white, and if you are working part-time, a judge is very likely to conclude that if you can work part-time, you could probably work full-time. So my suggestion is that you try to avoid working part-time if you certainly more than a trial work period or a unsuccessful work attempt is really the appropriate term, 3 months. So if you work more than 3 months, that looks like real work. So again, I would never tell somebody not to work, but if you do work, realize that it's going to affect your case, especially if you're working more than 3 months. And I think the main reason, the fourth and main reason that cases are denied, is the lack of a medical source statement. You need to have a doctor in your corner. That doctor needs to be willing to fill out a functional capacity form or write a brief narrative report, basically identifying activity limitations that apply to you because of your medical condition. It's not enough for a letter to say, my client's disabled. You need to be able to say, my client is disabled because, or and again, the forms we use, the functional capacity forms, talk about problems. For example, he might miss excessive days, 3 or 4 days of work a month, or he needs to take unscheduled breaks, or he can't use his left arm. You don't want to be as specific as you can, but having a medical source statement is really, in this climate, almost essential now. So those are really the main 4 reasons I'm finding that cases are being denied. So hopefully, if any of them apply to you, you can get working on it, talk to your lawyer, and try to avoid losing a case because of things that are certainly preventable that you can address and take care of prior to your hearing. Again, my name is Jonathan Ginsberg. I hope this has been helpful, and until next time, I'll talk to you soon.